Thank you, sir. I'm going to ask a few more questions the second round if anybody else wants to. But Mr. Brown, did the English courts ever decline jurisdiction over American authors under the theory that we have a different standard here, and they take that in consideration at all?
I'm not familiar with those cases. There may be one in some of the written testimony where there have been examples of English courts backing down on personal jurisdiction grounds. Laura, do you have?
Yes, I was an expert in one of them for Barron's in London in the Asakam Chadra case, which I mentioned in my testimony. There, they did find jurisdiction over a California technology company and its president, but they exercised forum nonconvenience and dismissed it based on forum nonconvenience, which is a discretionary basis, saying that the bulk of witnesses and testimony would be overseas. That has been more the exception than the rule in London, in my experience in these cases.
Professor Silverman, do you want to comment?
No, there are some examples with respect to abstention both in Canada and the United States. The only thing I wanted to say is that the suggestion that I made about adding to the bill a provision that said we would not recognize a judgment when the foreign court exercised what we might characterize as exorbitant jurisdiction from the U.S. point of view. And that might well be situations where the publication is in the U.S. and it gets picked up and there are a few hits on the internet site. The Europeans, the English, they have jurisdiction in a very different way than we do. They will take jurisdiction in those kinds of cases. It is true that most of those countries, Australia and England, I know, will issue damages only for the amount of injury that occurs in their jurisdiction, unlike in the U.S. But nonetheless, that has the interorum effect that we were talking about. But a provision that said when a foreign court exercises jurisdiction on a basis that's perceived as unreasonable in the United States, we would not recognize that judgment. I think that is in fact the law in the various states as well, but its interpretation differs.
Let's assume you sold a lot of books in England, and it was still they ruled against you. Isn't it just as much an infringement on the American belief in your right to express your thoughts? And shouldn't that judgment over there, even though there was a lot of damages there, shouldn't it still be unenforceable here because it's inhibiting our speech?
Yes, if in fact if it inhibits our speech, yes. I'm merely suggesting that there are really two prongs. I wasn't suggesting jurisdiction as a substitute for public policy. I was really suggesting, as the law is now, that there is a defense on grounds of public policy and there's a defense on grounds of an unreasonable exercise of jurisdiction.
Dr. Ehrenfeld talked about teeth. If we permitted attorney's fees, would that not be, I mean, maybe they'd be like, you know, tiny baby teeth, but they'd be teeth. Would that be something that would be okay?
Attorney's fees.
When you bring the action, you bring an action to say they want to enforce their judgment, you're bringing your action under our law saying it's unenforceable, and if you're successful in saying that, because they try to bring their action here to enforce their judgment, and they are thwarted because of our law, that then they have to pay attorney's fees for to the prevailing party here.
That is certainly teeth, and we certainly have given awards for prevailing parties in other situations when we deem that necessary. Yes.
And do you both agree, Ms. Handman and Mr. Brown? Something to be acceptable?
Yes, Your Honor. That is indeed what I've recommended.
I like that, but this is America, not England.
Sorry, I haven't. Mr. Chairman, yes, that's the amendment that we've suggested, and it would give teeth, and it's very similar to anti-SLAPP statutes, which are now in 25 states, where there are attorney's fees when someone brings an action that burdens speech, which indeed this would be a classic example of. And I would suggest that the attorney's fees should be able to reach any fees that were encountered in the British action as well, or the overseas action as well, any incurred there. That would put a little extra teeth in it, not just for defending the enforcement action, but also for whatever was incurred overseas. And in a way, it's only fitting, given that the British have that rule of fee shifting that's in place and has had a huge impact on American suit over there.
Yeah, that caught my attention when it was mentioned in the testimony, and it certainly would be teeth, and to work with Dr. Ehrenfeld, I did the slap suit and statute in Tennessee.
Oh,
so yeah,
congratulations.
thank you. Strategic lawsuit against political prisoners. They didn't really like that too much, Mr. Brown.
And maybe I could just add to that. In my written testimony, I discuss the different outcomes involving lawsuits brought against Cambridge University Press in the UK and Yale University Press in California, both involving books dealing with the financing of global terrorism. In the Cambridge case, the books were destroyed. Cambridge capitulated, wrote a very self-serving, apologetic letter to Mr. bin Mahfouz, who was the plaintiff there, which Mr. bin Mahfouz has well publicized. In the Yale case, Yale was in California. They had access to the California anti-SLAPP statute, which they used, and they filed a motion to dismiss the case. And the plaintiff in that case ended up dismissing even before the court had an opportunity to hear the anti-SLAPP motion. And as a colleague of mine pointed out to me just yesterday, the lawyer for the plaintiff in that case said, sounding more like a Harvard quarterback, that quote-unquote Yale came at us hard. And that's why they decided to drop their action in the face of the anti-SLAPP motion. So it is quite effective, that fee-shifting provision there.
Yes, Dr. Ehrenfeld, please.
In the case of Cambridge University Press, interesting to note that the lawyers for bin Mahfouz were asked why did he sue only the publishers and not the American authors of the book. They were not sued. And he responded that because Cambridge University is here in England, it's easy to sue. It's difficult to sue American writers now. This was following the New York legislation. So I think that with even that was a deterrence. But despite of what happened in Cambridge and despite the big publicity, there are the authors, or one author, the living author of Cambridge University, of Arms for Jihad, the book that Cambridge University pulled, cannot get a publisher here in the U.S. Because they are afraid that it will reach England and they don't want to publish it. It's a very good book. It should be published. In addition, there are Cambridge University Press actually defamed the authors, the American authors, but they cannot take any action against it because they don't want to get involved in expensive lawsuits. So the more deterrence we have, the bigger the teeth, I think, the better it will be.
So you like the attorney's fees idea?
I do.
And what if we require kind of a role reversal, the attorneys to give a third of whatever they get back to their client?
You have to have the attorneys here.
That would lose the bar's support. We can't do that. Has English defamation law at all changed and moved more toward our type of First Amendment protections, Ms. Handman?
Yes, Congressman, it has, and I take some small measure of credit for that. I do think the decisions in the U.S. have had that effect, and that's what I'm told by my colleagues who practice there. But it is nowhere near where our law is. The burden of proving truth is still on the defendant. The Reynolds case, which is the case that has allowed some small measure of fault to be considered, so that if you make a mistake, but if you did all the things that the Reynolds court said, get comment, act fairly, a whole host of a list of sort of what constitutes responsible journalism, then, and it's a matter of public concern, and they define that very narrowly, so that much of what in America would be deemed a matter of public concern would not fit within that definition. Then, even though you made a mistake, you may well be not liable, and that was the case in the Jamal case that was recently decided against Dow Jones. But in that case, even, what it is a standard very different than what the actual malice standard. Actual malice is basically deliberate falsehood. It is knowing it's false or having serious doubts about the truth and publishing it anyway. It's basically a bad faith kind of defense, and it's subjective. It's what's in the reporter's head. It's not a what do good journalists do standard, which is more like a negligence standard. That's a lower bar. But when there's public figures in the U.S., they have to prove that higher bar, and it's intentionally so, because that's the ability to make mistakes, basically, is what New York Times v. Sullivan enshrined. So they are not anywhere near that, and that's what I hear from my colleagues over there, and that's my own perception. Even the lawyers who got that great decision in the Jamil case say we're nowhere where you are, even on that fault standard. And also on opinion, they have a sort of reasonableness test. We have, if it's not a statement provable as true or false, it's opinion, and you can't be sued for it. And then the judge doesn't get to say whether it's a good opinion or a bad opinion. That's a huge difference also. And there are many other smaller things like that, in terms of jurisdiction, in terms of statute of limitations, that make a huge difference as well. But those are the main things, and it's really not anywhere near where we are yet.
Thank you. Is there who wants to comment? Professor?
If I could just briefly, of course, that they are changing. I think we've seen that the European Convention on Human Rights and the International Covenant of Civil and Political Rights are having an impact on the laws of many countries. And I think it's important to remember that when we talk about what I characterized as the nuance, as to how far we want to go. I mean, and who is affected, whether it's a foreign plaintiff, whether it's an English plaintiff who's injured in England. I mean, we could just take the mirror image. Imagine a place that had no protection for libel law, no defamation law whatsoever, and they publish and a U.S. citizen is injured and wants to sue for defamation. It meets with our standards, and so there would be a cause of action, but there would be no protection on the foreign law, and the United States issues a judgment. I mean, we would think that we had the relevant interest when there was a publication here and there was a U.S. plaintiff. We would think we had every right to regulate that, regardless of what had been done in the other country. And so I just suggest, as I often do in these kinds of cases, for us to stand in the shoes of the other country and look at where the publication is, who is the resident. All of those things will be relevant in terms of the public policy, and I think it is important that these changes are occurring and that there are not quite the same wide gaps of difference in the libel laws.
And I would just add to that, I think, briefly, that the fact that we're here today is something that is putting pressure on UK lawmakers. I think you'll see in the written testimony that there have been debates in Parliament quite recently about the phenomenon of libel tourism, and I think there are many MPs who are embarrassed by what they see happening in the UK courts, and I think the publicity we're giving to the issue today is another thing that will help perhaps reform UK libel law. The Reynolds defense that Laura mentioned, it's only 10 years old. We've had 45 years experience under New York Times versus Sullivan. But I would say that as it's been described by some as a test in which judges look back after publication and make some kind of evaluation about whether a publication was fair. Fairness is not a concept in American libel law, and for those of us who practice in this area, one of the most famous articulations of that is Judge Libel in the famous Westmoreland case, who said that a publication can be relentlessly one-sided and unfair and still be protected by the actual malice rule. And I think that in all likelihood, the Reynolds defense will never catch up with where actual malice is. And one final point, I think just another twist in UK libel law is that they still routinely enjoin authors and publishers. And I think there's nothing more perverse than the fact that Dr. Ehrenfeld here, who made no intent at all to have her book published in the UK, is now, I understand it, still under an injunction, right, and could be held in contempt of court if a book that she never intended to be available to a UK audience somehow is published there again or is available there again. And I can't imagine a more perverse miscarriage of justice than that.
Doctor?
Regarding the Jamil case and the changes in the British law, the decision, Lord Hoffman said in that case, and I think that the decision was that the measure is how responsible reporters report. So who will decide who is the responsible reporter? Should we leave it to the court? That's an important question. So I don't think that that's really, it's a movement towards a change, but it's not a real change. Regarding other changes, I understand that the British Bar is now discussing changes in the structure of payments of defendants in libel lawsuits. That's as far as I know the changes that they are discussing, but not really about the libel laws themselves.
Thank you. I don't believe there are any further questions, and if not, I'd like to thank all the witnesses for their attendance and their testimony. Without objection, members will have 5 legislative days to submit any additional written questions, which we'll forward to the witnesses and ask you answer as promptly as you can. They'll be made part of the record. The record will remain open for 5 legislative days for the submission of any other additional materials. Materials have been forwarded to us, and the request had been made to have them included in the record, and without objection they will be made so. A statement from the World Press Freedom Committee with appendices, a letter from John J. Walsh to me, a statement from the American Association of American Publishers, a statement from the American Jewish Congress, and a statement from the American Civil Liberties Union. Without objection, that's done. I thank everyone for their time and patience. This hearing of the Subcommittee of Commercial Administrative Law is adjourned.